Hello everyone, my name is Satyam Shivaach and I am working as a legal intern with LEXIS and Company. And in this video, we will discuss about the sexual harassment of women in workplace. In 1997, our Honorable Supreme Court in Visakhapatnam versus State of Rajasthan acknowledged the gravity of sexual harassment of working women at workplaces and laid down guidelines making it mandatory for employers to prevent the commission of act of sexual harassment and to provide the procedure for resolution, settlement, or prosecution of act of sexual harassment. The guidelines issued by the Honorable Supreme Court were treated as law declared by the court under Article 141 of the Indian Constitution. It was held by the court that the guidelines framed would be strictly observed in all the workplaces for the prevention and enforcement of the right to gender equality of the working woman. Moreover, it was observed by the various courts from time to time in the past that the guidelines and the norms framed by the Honorable Supreme Court have not been followed in workplace strictly. The increasing work participation rate of women made it imperative for enacting a comprehensive legislation focusing on prevention of sexual harassment as well as providing a redressal mechanism. Now let's see the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. In 2013, after a span of 16 years, India finally enacted a Sexual Harassment of Workplaces Act for prevention of sexual harassment against women at workplaces. The central government, by notification, appointed 9th December 2013 as a date on which the provision of Act came into force. On the same day, the central government made the Sexual Harassment of Women at Workplace Rule 2013. Now, what are the objectives of this Act? The Act is enabled by the Indian Parliament to provide protection against sexual harassment of women at workplace and the prevention, redressal and complaint of the sexual harassment and for matter connected therewith. Sexual harassment is termed as the violation of the fundamental right of women to equality under Article 14 and 15 of the Constitution. Moreover, it also infringes the right to life and to live with dignity under Article 21. Sexual harassment is also considered a violation of right to practice any profession or to carry occupation, trade or business with indulge a right to safe environment and free from sexual harassment. Now let's see the definition of sexual harassment. The Act has adopted the definition of sexual harassment from the Vishaka judgment, and the term sexual harassment includes any unwelcome act or behavior, whether directly or by implication, such as physical contact and advances, demand or request for sexual favors, making sexually colored remark, showing pornography, or any other unwelcome physical, verbal, and non-verbal conduct by the sexual nature. In Apparel Export Promotion Council versus A.K. Chopra, the Honorable Supreme Court, while deciding an issue whether the act of the superior officer wherein such superior officer tried to molest his junior woman employee would amount to sexual harassment. The court relied on the definition of the term sexual harassment laid down by the Supreme Court, which is similar to the definition of sexual harassment provided in the Act, and held that the act of respondent was unbecoming of good conduct and behavior expected from a superior officer and undoubtedly amount to sexual harassment. The Section 3 of the Act provides that no woman shall be subject to sexual harassment at any workplace. The section further provides that the circumstances which, if present or connected with any act of behavior or sexual harassment, may amount to sexual harassment, such as implied or expressed promise to preferential treatment or implied or explicit treatment of detrimental treatment in her employment, implied or explicit threat about her parent or future employment, interference with work or creating an intimidating or offensive or hostile work environment, humiliating treatment likely or to affect health or safety of a woman. Now let's see the complaint committee and complaint procedure. First, there is internal complaint committee. The act made it mandatory for every employer to constitute an internal complaint committee which entertains the complaint made by aggrieved women, and the member of the internal complaint committee are to be nominated by the employer, and the ICC should consist of presiding officer and no less than two members from amongst employee preferably committed to the cause of women or women who have experience in social work or have legal knowledge. Moreover, one member from amongst non-governmental organization or association committed in case of women or a person familiar with the issue related to sexual harassment. And in order to ensure participation of women employees in the ICC proceeding, the Act requires at least one half of the member of ICC nominated by employer are women. Now, then the next is the local complaint committee. Provisions are provided under the Act to form a local complaint committee for every district for receiving complaint of sexual harassment from establishment where ICC has not been formed due to having workmen of less than 10. Then, what is the complaint procedure? The Act stipulates that aggrieved women can make a written complaint of sexual harassment at workplace to the ICC or to the LCC in case of a complaint is against the employer. First, a period of 3 months from the date of the incident, and in case of the series of incident, within a period of 3 months from the date of the last incident. If the aggrieved woman is unable to make a complaint in writing, reasonable assistance shall be rendered by the presiding officer or any member of the ICC. In case of the aggrieved woman is unable to make complaint in writing to the LLC, the reasonable assistance shall be rendered by the chairperson or any member of the LCC for making the complaint in writing. And as per the Sexual Harassment of Women at Workplaces Act Rule 2013, in case of the aggrieved woman is unable to make a complaint on account of her physical incapability, a complaint may be filed inter alia by her relative or friends, or by her co-worker, or by any officer of the National Commission of Women or State Women Commission, or any person who has the knowledge of the incident with the written consent of the aggrieved woman. Now let's see the confidentiality of the Act. The statute provides specifically stipulates that information pertaining to women's sexual harassment shall not be subjected to provision of the RTI. The statute further prohibits dissemination of the content of the complaint, the identity and address of the complaint respondent witness, or any information relating to the conciliation and inquiry proceeding, or any recommendation of the ICC or LCC, and the action taken to the public press and media in any manner. I would like to conclude by saying that undoubtedly the guidelines and norms were framed by the Supreme Court in Shivaach case are fountain of the Act, but with the passage of time it was felt that the guidelines and norms are not sufficient to deal with the incident of sexual harassment. And a strong piece of legislation is in need of the hour, and according to the Act was enacted in 2013. The Act went one step ahead and included various issues which remained unaddressed in the past, such as extension of the definition of workplace and to include almost all type of establishment, including a private sector organization, dwelling places or houses, inclusion of the term domestic worker and unorganized sector in order to address the issue of sexual harassment of women at workplaces. That is all for today's video. Thank you for watching. Please like, share and subscribe.